Well, thank you very much, and I'd like to thank the National Citizens Inquiry. It's a great honor to be invited to testify on this question, are children safe in Canada? And I want to preface my remarks by also thanking the National Citizens Inquiry for doing the heavy lifting on the important work, going back 2 years ago, of actually looking at the lockdown harms. Our governments, federally and provincially, failed us abysmally, did not comply with the Constitution in assessing both lockdown and vaccine passport benefits and harms and weighing the two. The Constitution of Canada requires governments to identify and weigh and measure both harms and benefits. If you have a health order or a vaccine passport that violates fundamental charter rights and freedoms. So I want to thank the National Citizens Inquiry for doing really what governments ought to have been doing themselves in 2020, 21, 22, and they failed to do this, but the NCI stepped up to the plate for that important work. So thank you for that. Are children safe in Canada? My answer, not as safe as they could be or should be. The good news is that there are, most of the laws in place are actually good for protecting children, protecting the rights of parents to nurture and provide for and guide and protect their own children. I will start with, this is going back a few decades, but the Universal Declaration of Human Rights states in Article 16, quote, "The family is the natural and fundamental group unit of society and is entitled to protection by society and the state," end quote. This is from 1948. This was when it was fresh in everyone's minds. National Socialism in Germany had very recently, only 3 years prior, had been defeated, and this was one regime, certainly not the only one, but this was one regime where the leader of the National Socialists said more than once, it doesn't matter what you old people think, we've got your kids, we've got the minds of your kids, so we're going to bring about a glorious future because we're properly indoctrinating children into the ideology. And so it's not a coincidence that when only 3 years after the end of the Second World War, when people were contemplating what should human rights consist of, this was in there, the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. So that's foundational. So this has been reflected in laws. For example, and just one example, the Alberta Family Law Act states that parents and guardians are entitled to be informed of and consulted about and to make all significant decisions affecting the child. That is the law in the province of Alberta, and presumably other provinces have similar legislation that expressly empowers parents and guardians to make all significant decisions affecting the child. Alberta's Act says, including the child's education, and that includes participation in extracurricular activities. The Supreme Court of Canada, in a 1995 ruling known as BR versus Children's Aid Society of Metropolitan Toronto, interpreted Charter Section 7, right to life, liberty, and security of the person, and said, the right to nurture a child, to care for its development, and to make decisions for it in fundamental matters such as medical care are part of the liberty interest of a parent. So a Supreme Court of Canada recognizes that a parent has a charter right to liberty, and that right to liberty includes the right to make decisions for children in medical care and other things. Quoting from the decision again, the common law has long recognized that parents are in the best position to take care of their children and make all the decisions necessary to ensure their well-being. The view of the child's welfare conceives it to lie, first, within the warmth and security of the home provided by his parents. This recognition was based on the presumption that parents act in the best interest of their children. Now, we see an ideology promoted often by the government-funded media and elsewhere that holds parents out as dangerous, abusive, untrustworthy, and therefore parents need to be kept in the dark about what's going on with their own children in school. But there's an old saying, a hard case does not make for a good law. And of course, and sadly, there are parents who really are abusive, and it really is in the child's best interest for the child to be removed from the care of a very small number of parents who are truly abusive. But to twist that into this notion that somehow children need to be protected from their own parents because parents generally are dangerous and abusive, that's analogous to saying that because there are a few impaired drivers on the road, everybody should have their driver's license taken away. Well, no, there are some impaired drivers who should be, should not be on the road, but that doesn't change that the fact that we should be able to have a driver's license and drive a car. In the same way, you have a very small number of abusive parents, and that does not mean that all parents should lose their right to care for their children, to nurture their children, to protect their children, to provide for the moral upbringing of their children, et cetera, et cetera. So the law is there. There was a crazy YouTube video came out some 2-3 years ago by a law prof at the University of Alberta who said that parental rights was just an American concept and had no foundation in Canadian law. But he or she, not clear from the video, obviously not familiar with the Supreme Court's ruling in BR versus Children's Aid Society of Metropolitan Toronto. Now, there are challenges with the law not being necessarily respected and applied. In one of the Justice Centre's court cases, affidavit from a girl in Ontario that was filed with the court at the age of around 10 was doing a lot of reading on the internet, watching a lot of LGBTQ YouTube videos, and became persuaded by these videos that claimed that if you are anxious or uncomfortable with your body, that means you're probably transgender. Which is a bit of a stretch. I would venture a guess most people in this room, if not currently, maybe at least at some point in your life, you felt anxious or uncomfortable about your own body. But here this girl is persuaded by the internet that this means that she's transgender because she doesn't feel comfortable with her own body. She first decides that she's non-binary, goes into wanting to use pronouns they and them. Later on, she felt increasingly that she was a boy and came out as a boy at school, and the principal says, this is great, and you can use the boys' washroom, boys' change room, and we're not going to tell your parents. The parents did find out about it later. We're not supportive of the girl calling herself a boy and so on, and the principal told the student, your parents are abusive. They're abusive because they do not support your desire to become a boy. And phones Children's Aid Society, which repeatedly visits the home. The girl stumbled across a book called Irreversible Damage by Abigail Schreier, which records the stories of people that have detransitioned, and her father discouraged her from reading the book and said, you probably won't like it and you shouldn't read it. And she read the book and related to the stories of detransitioners, and stories got a happy ending that she did decide that she had been misled and deceived, and that things would have been better if the school had not kept secrets from her. Case in Alberta, similar. This was a court case going back to 2018 when we had Bill 24, which prohibited Alberta's principals and teachers from informing parents about what's going on in their own, with their own children in the context of gay-straight alliances at school. There was an autistic girl, and this is an affidavit filed with the courts, who was diagnosed with autism at the age of 5. She also struggled with anorexia at various points. She was a tomboy. She liked breakdancing. She didn't like the stereotypical girly things. And she was encouraged to join this gay-straight alliance. And their transgender ideology promoted to the children without the parents knowing. And she starts to live a double life of being a boy at school. And but her parents are not informed about this. They're kept in the dark. And so that's a practical challenge. What can we do about it? What parents can do, firstly, if your child is getting subjected to, if transgender ideology is being promoted in the school where your children attend, take your children out, homeschool them, put them in a different school. I know that's incredibly difficult for some families. If you're middle income or lower income, both parents are working, perhaps you don't have grandparents or aunts or uncles to help. So that can be very difficult. But the other very important thing is to get to know your teacher and your principal and be engaged, be involved, be informed, and also be engaged in the democratic process. There's an old proverb from Edmund Burke: the only thing necessary for evil to triumph is for good people to do nothing. There's an old French proverb: if you don't do politics, then politics will be done unto you. And in a similar fashion, 2,500 years ago, Plato said, and this is a paraphrase, not a quote, but those who refuse to be involved in the democratic process will suffer the consequence of being governed by their inferiors. So that's the action plan, is to be an informed and engaged citizen. And I will stop there and welcome any questions. Thank you.
I'm going to turn it over to the commissioners. Does anybody have any questions for John? What? No questions? There's one.
Mr. Carpay, you've said at the outset, with respect to the sort of overarching question as to whether children are safe in the country, you've said for the most part, because there are laws in place and there's the Supreme Court of Canada authority vesting or recognizing the inherent paramount authority of parents over the interests of their children. But we, of course, know what's been happening in the schools. And we also know as to the growth of administrative law principles which preclude any effective challenge to the exercise of discretion by delegated authorities, some of whom can really impact the interests of kids, and how the Charter has become, the sound of a distant dog barking with respect to challenging the exercise of administrative authorities. So I'm wondering if in the context of this evolving landscape that makes any sort of constitutional challenge very difficult, are you able to sort of revisit your opening remarks about the laws being in place in the context of this other evolving legal landscape?
Well, the good news in a way is that, well, it's neither good nor bad. I think it's a fact. Politicians they tend to be followers more so than leaders. And when our elected representatives, federally, provincially, municipally, school board level, become aware that the majority of people reject this transgender ideology, do not see it as a good thing for children, do not see it as helpful, do not see it as positive, then they're likely to follow suit. It is, because of trends in constitutional law, and I address this in my book, Corrupted by Fear, where I review cases where the judge writes the media narrative into a court ruling and writes what he's heard on the 6 o'clock news, even though it's not supported by evidence placed before the court. So we've got a big problem. So engagement in the democratic process is more important, I would say, than 20 or 30 years ago, where I think you had more respect for the rule of law in the courts.
Mm-hmm. I mean, it's beyond the sort of whole area of gender ideology. It goes into healthcare, sort of the mandatory coercive nature of vaccines as the obvious example, and the divesting of parents of their authority over this, contrary to those principles expressed by the Supreme Court of Canada. The state's taking over. It's, in a sense, ongoing sort of efforts to disenfranchise parents and vest power over the kids in the state. Do you get a sense of that happening?
Yes, but it can be counteracted. We've seen, for example, in Saskatchewan and Alberta, we've had 2 premiers that have articulated policies, which I believe in Alberta have been passed into law, whereby parents must be notified of certain things, and specific details I don't have in front of me, but things like puberty blockers or using opposite sex pronouns at school, et cetera, et cetera. So these are things that citizens can and should lobby for provincially to say, we want, I mean, if there's a provincial law that says the school must inform the parents of such and such, okay, yes, I suppose laws can always be disregarded by principals and teachers, but if the law is in place and it's clear, you're going to get a lot less of the bad stuff than when you don't have that kind of a law in place.
Mm-hmm.
I'd like to hear you about the politicization of the Supreme Court of Canada. I'm thinking about the Barry Norfield case, for example. And also the fact that I don't know of any COVID-19 case that was accepted by the Supreme Court of Canada to be heard. So can we still use the tribunals to fight for constitutional rights and freedoms?
Well, we have to do the best we can. Certainly the lawyers in our network, we always strive to put forward a case that is so strong and so compelling with expert testimony and evidence that is so strong that if we don't win, it's the court that ends up not looking good. That's a standard that we seek to achieve. But again, I think involvement in the democratic process is even more important today than what it would have been 20 or 30 years ago, because if the judges are corrupted by ideology, or if they're corrupted by fear, or if they're writing a media narrative into their court rulings that is not supported by evidence placed before the court, as I've provided examples of in my book, then it's more important now than ever before to elect people federally, provincially, municipally that really cherish the free society and that really cherish and appreciate our charter rights and freedoms.
Thank you.
Mr. Carpay, what do you think about the issue of professional bodies like medical colleges and law societies, who seem these days to be reluctant to do anything except to lean heavily on professionals who are trying to promote honesty?
Legislative reform is the first solution that comes to mind. It's not that hard for a province to change the Legal Profession Act and say, for example, one example of a possible change is that complaints against lawyers may only be brought in respect of how the lawyer performed his or her duties for the client, if there's a restriction. Currently, there's this broad catch-all conduct unbecoming of a lawyer, which can mean anything. And so I know lawyers that have faced disciplinary proceedings over something that a political opinion expressed in public becomes, as we saw with Jordan Peterson and the Ontario College of Psychologists, that a lawyer's public statement on of personal opinion on a political or moral issue becomes the basis for disciplinary proceedings. And what happened during lockdowns with the colleges of physicians and surgeons was just horrific. These people were awful and completely anti-science in the way that they shut down debate. Science is all about debate. So I think that, sure, by all means, court actions, where appropriate, should be brought against law societies and colleges. But the quicker, simpler, easier, and more certain way to address that is for provincial governments to amend the legislation and say, the College of Physicians and Surgeons of Alberta, Quebec, British Columbia, what have you, shall not silence or stifle debate on medical issues. That's just off the top of my head. I'm sure better wording is available. But we can amend this legislation to restrict the scope of the professional bodies so that they're focused on what they should be. Like, is a lawyer stealing trust funds, or is a medical doctor having sex with his patients? Those are the types of ethical issues that those bodies should be limited to. So legislative reform is what I would say.
Any more questions, commissioners? I just have a quick one, John. You mentioned Charter Section 7 and parental rights under that, and then you said that Bill 24, I'm assuming that's an Alberta bill.
Yes.
That basically prohibited teachers from telling parents. So does that mean that provincial legislation now can overrule federal laws, in particular federal laws that supposedly are a part of our Constitution?
Okay. Well, the good news on Bill 24 was it was repealed. The Justice Centre's lawyers commenced a court action against it, which I think had this is hypothetical and speculative, but I think it had an impact on given the official opposition at the time the courage to take a position against Bill 24. I don't think they would have done that if we hadn't started a court action and been the tip of the spear, and willing to be called hateful and homophobic and all kinds of names. But we commenced a court action against Bill 24, which I think played a role in having the official opposition take a position against Bill 24. Then when there was a change of government, the new government repealed Bill 24. So that's kind of the story behind that.
Oh. So. But I think just to make my point again, the 1982 bill, the Constitution Act, I think it's called, of Canada, basically is where the charter is located. But is the position still then that a provincial act can overrule the charter?
Well, no. I mean, unless the government uses the notwithstanding clause,
okay.
the charter would apply to both provincial and federal legislation.
Okay, on behalf of the National Citizens Inquiry, thank you so much, John, for coming and giving us your time and your expertise.
Well, thank you.
Yep.